Okay, thanks for waiting on us. So now we'll look forward to getting the presentation from Sergeant First Class Sowash. Thank you for being here, and thanks for the work that you're doing. You're recognized for 5 minutes.
Thank you. Good afternoon, Chairwoman, and the rest of the committee. I am Sergeant First Class Sowash. I'm a U.S. Army Reservist, and I'm sure you all know Army Reservists are also civilians with jobs on the outside. So I'm also Vice President of Business Development for DirectEmployers Association, and I would like to share with you parts of the National Labor Exchange that actually focuses on getting veterans jobs, which is very near and dear to my heart. So first thing we do is we go to the National Labor Exchange, and we've got areas of interest, or you can actually just come over here to the actual veterans JPEG, and it'll take you to our Vet Central site. Now this site is focused on being able to help veterans to find jobs, and also to be able to single out federal contractors for veterans. You can search via keyword, which is very common on the internet. But you can also search, if you're in the military, you can search by your MOS or your MOC or what have you. So if you actually put in, let's say, for instance, 63 Juliet, enlisted in the Army. I'm just doing open search with that. Then you'll actually see that that MOS actually crosses over and pushes out civilian jobs that are comparable to the tasks, or I should say the skill sets that that military person actually had. So as opposed to them trying to think of different keywords that would fit them, they can just put their MOS in, and they can see different jobs that focus on what they've done in their experience. As you can see, little American flags, those denote federal contractors, obviously, who give preference to veterans, which is obviously very important. If a veteran wants to only see jobs from federal contractors, all they have to do is press this link right here, and all that will show are jobs that are federal contractor jobs. One thing that is extremely important that we believe from Direct Employers Association is we actually we have the best interests of our member companies in mind, because we're a nonprofit and we represent close to 500 of the Fortune 500 companies. So what we do is we send the veteran, we send the job seeker directly to, as you can see, it's directly to the job on the corporate site. So this allows the job seeker to apply directly to the company as opposed to a third party. And it makes it much easier for the job seeker to get into the corporate database as opposed to applying to a third-party database. So again, trying to be more efficient and help with labor market efficiencies, as obviously on the other side of the ball, trying to get veterans jobs as quick as humanly possible. We back out to just the home site. You can see again, you can do any sort of keyword type of search. Look for mechanic in Iowa. And once again, you'll see the federal contractors jobs, and you can go ahead and just focus on the federal contractor jobs and click right through to the corporate site. This job is actually on the corporate site, so when I'm applying right here, I'm applying to that company. I'm not applying off to a job board or what have you. Do this real quick, and I'll actually give you an idea of the companies that comprise Direct Employers Association. And again, these companies, when America's Job Bank went away, wanted to, needed to, had to get their jobs down to the local level so that veterans could have an opportunity to actually see their jobs. So this is one of the mechanisms that was used, was a web interface, was Vet Central. The main mechanism that's actually used is email. We email well over 3,500 different local veterans representatives and different local Wagner-Pizer locations with opportunities on a daily basis. So when a veteran walks through the door, and obviously if a vet rep have these emails sent to them on a daily basis, they will have new and fresh jobs available to them. I appreciate the time.
Thank you for the presentation.
Thank you.
Very helpful. Ms. Roof, you're now recognized. Welcome back to the subcommittee.
Thank you very much. Glad to be back. Madam Chairwoman, Ranking Member Bozeman, and distinguished members of the subcommittee, on behalf of AMVETS, I extend our gratitude for being given the opportunity to discuss and share with you our views and recommendations on Veterans Affairs contracting policies relating to Title 38, Section 4212. AMVETS believes that the use of qualified veterans in federal contracts is vital to the reintegration and business success of our veteran community. AMVETS also believes that veterans deserve a full opportunity to participate in the economic system sustained by their service. The committee has my complete statement for the record, and in my oral statement today, I'd like to focus on compliance auditing, ensuring Title 38, Section 4212 law is withheld in all VA contracts. Contractors are required to develop and implement an affirmative action plan that complies with regulations that support 3 separate federal laws, as we're discussing today. These are Executive Order 11246 amended, the Rehabilitation Act of 1973, and VEVRA. Aside from VA, there are 2 agencies in place to perform the oversight of these laws, the DOL and their OFCCP. The OFCCP is charged with monitoring federal contracts for compliance to these 3 laws, as well as investigating any complaints against employers bound to these laws by a federal contract. It is important to remember these laws encompass both contractors and subcontractors involved in any procurement process with the government. Performing audits and compliancy testing of federal contracts are important tools to ensure that the purpose for the agreement and the performance of the contract actually occurs, and that all Title 38, Section 4212 compliance is maintained throughout the entire contract. VA lacks reasonable assurance at minimum that it is receiving the services that it is paid for, and that contractors are taking all necessary steps to ensure our veterans' rights under Title 38 are protected. To AMVET's knowledge, VA rarely performs any compliance audits of completed projects. In non-government owned and operated businesses, audits of contracts often occur up to 5 years upon contract completion. AMVETS recommends that VA include and enforce more uniformly this practice, as well as contractors' performance under the contract. This provides validation to VA that all terms of the contract, most importantly, ones regarding Title 38, Section 4212, were met and completed in the agreed manner. AMVETS believes compliance audits are essential to the stability of a contracting system. It is in the opinion of AMVETS that a major impediment to current VA contracting policy is that of reactionary audits, or audits that occur after a problem is identified. Over the past few years, VA, OFCCP, and DOL audits have shifted from enforcement to more reactionary compliance audits. Enforcement audits will allow VA to accurately validate and measure the current processes in place, identify those that need enhancement, and isolate weak processes that lead to fraud, collusion, and most importantly, infringements to the Title 38, Section 4212, which protect our veterans' population's business success. AMVETS recommends the reimplementation and regular use of enforcement-based audits. AMVETS believes that a contributing factor in the failure of current compliance testing methods is on the overall process itself. VA and OFCCP compliance auditing methods are unnecessarily lengthy, in our opinion, and lack accountability and uniformity. This reactionary style of auditing federal contracts has proven ineffective to OFCCP because of the challenges it faces in locating former employees and records to substantiate the allegations of discrimination. These types of audits usually occur in small settlements. Unfortunately, the small settlement option not only costs VA millions of dollars every year, but more importantly, it costs our veterans their due entitlements sustained by their service. Madam Chairwoman, members of the subcommittee, AMVETS thanks you today for inviting us to partake in this discussion and is available for questions.
Thank you for your testimony. Mr. Sharpe, you're now recognized for 5 minutes.
Madam Chairman and Ranking Member Boozman, and members of the subcommittee, thank you for the opportunity to appear before you to discuss federal contract compliance. In the Federal Register of August 8, 2007, OFCCP significantly expanded the responsibilities of federal contractors concerning their affirmative action plan for veterans. The Federal Register noted that federal contractors are required to conduct active outreach to find veterans going far beyond their posting their internet listings. Persons and organizations that federal contractors are directed to partner with to ensure appropriate outreach for eligible veterans are the local Veterans Employment Representatives, the Department of Veteran Affairs Regional Office, veteran counselors and coordinators on college campuses, and the service officers of national veteran groups active in the area of the contractor's establishment. Based upon dialogue with local veterans employment representatives, veterans, and other organizations across the country, the American Legion found that federal contractors have not consistently enlisted the assistance and support of the above-mentioned persons and organizations in recruiting and developing on-the-job training opportunities for qualified disabled veterans, recently separated veterans, other protected veterans, and armed forces service medal veterans, to fulfill its commitment to provide meaningful employment opportunities to such veterans. The American Legion recommends that a VETS 100 report should no longer be filed electronically because it goes around the law's intent of bringing employers and the one-step career centers together to discuss and develop employment opportunities for veterans. The American Legion also recommends VETS 100 be amended to measure direct compliance with OFCCP regulations. And additionally, the American Legion recommends that the Federal Contract Veterans Employment Program, presently under OFCCP, should be placed under the direction of the Department of Labor's Veterans Employment and Training Services, so this program can receive proper oversight as well as input and guidance from stakeholders. It is vital for eligible veterans to receive a fair and proportionate amount of federal employment from federal contractors, so these veterans can build and maintain a quality of life while they contribute to the United States economy. Madam Chairman, that concludes my statement.
Thank you, Mr. Sharpe. Mr. Weidman, welcome back to the subcommittee. You're now recognized for 5 minutes.
Thank you, Madam Chairwoman, and Mr. Bozeman, Mr. Moran, good to see you again, and Mr. Teague. The FCJL started in the Readjustment Act of 1973, and was an effort by many members of Congress to do something for Vietnam veterans who were struggling in a terrible job market when we came home in the early 70s, which was only compounded by the OPEC-induced gas shortage, which only drove that recession to be much longer and much deeper than anybody anticipated. It was a well-meaning thing, but any kind of law that is passed without a mechanism for enforcement and implementation and compliance simply begs the question. Unfortunately, OFCCP is full of terrific people like the gentleman who has sent up his sacrificial lamb this morning, Lorenzo Harrison, and Mr. Teague. He's a born-again New Yorker. As soon as he could leave Teaneck, New Jersey, he moved to the city, so be easy on him. The problem is they're not set up to be able to do their job. They don't do their job for women, they don't do their job for ethnic minorities, and they don't do it for vets, simply because they do not have the tools. In about 2000, 2001, my good friend Jerry Solomon, upstate New York congressman, pushed hard to have improvements made to the VETS 100 report. And that was then incorporated in the Jobs for Veterans Act as well. And then it took 5 years plus to finally get the regulations in 2007, which have mostly been observed in the breach. The question is, what do you do with the information and who enforces it? Perhaps moving it to VETS would help, but frankly, we doubt it. The entire set of tools, whether that in the public labor exchange model of the DevOps LVERs, OFCCP, federal contract job listings, and every other tool that we have depends upon a public labor exchange that works. And I would submit to you, to this distinguished body today, that we do not have a public labor exchange that works properly, and certainly does not work properly for veterans. I have recommended a number of steps on behalf of Vietnam Veterans of America that would take us to a point where perhaps we could do this, have something that actually worked for the young people coming home. First and foremost, we urge that you federalize the DevOps and LVERs and have them report directly to the DVETs across the country. In many cases where the labor exchange actually does work, and there are states like South Dakota, and you're fortunate, Madam Chairwoman, that you have a state where it does work pretty well, and it works pretty well for vets too. But in most states like New York, it doesn't work well at all. And so on a memorandum of agreement, those now federal employees, DevOps and LVRs, could go right back into the same office on a memorandum of understanding, if in fact it is an atmosphere that is truly practicing priority of service to veterans, and in fact it's conducive to assisting veterans, particularly disabled and recently separated veterans. So it's a tool that would allow us to continue where it's working, and where it's not working, to have alternatives to make it work. Secondly, we now have a Secretary of Labor who is deeply committed to veterans, and her track record in the Congress suggests that she will, in fact, take steps to do it. But we also need an Assistant Secretary for Employment and Training who is committed. That's where the power lies, and that's where the money lies at the Department of Labor. And until we have an Assistant Secretary of Employment and Training who is as committed to veterans as the Assistant Secretary for Veterans Employment and Training, as well as a Secretary and a Deputy Secretary, we're not going to get much headway. Thirdly, there needs to be a significant increase in the funding for the DevOps LVER program to at least $200 million for FY 2010. Fourth, the Secretary of Labor needs to commit significant amounts of discretionary WIA funds to reward the states that do the best job in providing actual employment and training services. Fifth, employers who are federal contractors, and if you do all those, we'll start to have an effective DevOps LVER system again. And then if you have employers who are federal contractors who want to do the right thing and who now need to have a signature from the local veterans employment representative that in fact they have listed their jobs in that state where that location is, and that point, without that, then they would be barred from seeking further contracts or securing contracts extensions. If there's no teeth, there's might as well not do the law. There has to be some mechanism for enforcement that is not over labor intensive, no pun intended. And six, since OFCCP is not now, nor has it ever been effective, VVA proposes that veterans be given the right to sue federal contractors for discrimination when they do not hire veterans, with up to $300,000 punitive damages in addition to any actual damages plus attorney's fees. It will only take a very few cases, and the rest of the contractors will be coming and beating their way to the LVER's door to get signed up and to list jobs and to follow through with a proper plan to seek and hire qualified veterans, particularly those young people coming home today and those who are disabled veterans. I thank you. I see my 5 minutes up, and thank you for the opportunity to share these thoughts with you today, Madam Chairwoman.
Thank you, Mr. Weidman. What value do you place on the VETS 100 report?
In the absence of an effective mechanism in order to do job matching, we don't place a lot. I must admit I was surprised today because I know of most of the military job boards, and had never heard of Vets Connect, so I apologize to the distinguished vice president of that outfit for never having heard of it. And there has to be a way to get the listing of jobs to the individual. The first public labor exchange was in New York City, founded in 1835 because it became too big for the village green to work anymore. And similarly, because in our country, the reason why we have veterans preference, the reason why we have service disabled veteran Business set-asides, and the reason why we have OFCCP for federal contractors is because we don't have bounty lands to give away to veterans as a reward for service and sacrifices made. And so we need a mechanism whereby first dibs on jobs either in the federal workforce or in the federal contractor workforce can go to qualified veterans. And we need some kind of mechanism to close that gap, ma'am. And we don't have that mechanism today.
Okay, well, your response, what you just said in terms of not being aware of the Vet Central website was going to be a question I was going to ask the sergeant. But let me just ask each of you a question related to this. Mr. Weidman, do you think it was a mistake to terminate the America's Job Bank? And what is your opinion of its private sector successor, Job Central, with the technical operations being conducted by DirectEmployers Association and the website that they've created that you saw today? And then my question, Sergeant, is how do veterans learn of this website? So, Mr. Weidman, if you could answer first.
At the risk of reliving and reviving bad history, I thought that the way in which and the fact of ending the public labor exchange and America's Job Bank, given the number of states that depended on that mechanism, was highly irresponsible and a shameful decision and a shameful action. The transfer over, if you will, to Vet Central, as you might well imagine, Madam Chairwoman, I keep up on a lot of stuff when it comes to economic affairs and veterans, and was not aware of Job Central and what their Vet Central and what they were doing in the same way. And I do not believe that it has replaced what we had 15 years ago when we had at least something that approached an effective public labor exchange on a national basis.
Thank you, Madam Chairwoman. When America's Job Bank did go away, the employers mobilized to be able to create something that would replace it, especially with regard to getting jobs down to veterans at the local level. And I'm assuming after this session, we'll have an opportunity to actually speak and get you a little bit more educated about the National Labor Exchange the way it is today, because there are actually more. We have 48 states that are actually participating in the National Labor Exchange, which actually is more than America's Job Bank had when it went away, which is very surprising to me right out of the gates with regard to uploads of jobs and downloads of jobs. When we created the National Labor Exchange, along with our partners NASWA, we actually went down to the state level and we asked them what they liked about AJB and what they didn't like about AJB. And that's where we started. That was ground zero for us in creating a new National Labor Exchange and actually creating relationships with North Carolina and other states and being able to understand what happens at the local level so that we can get jobs down to the local level and we can ensure that when veterans come through the door, they have jobs available to them. So I think this is actually more of an awareness for maybe this whole room and maybe even more that the National Labor Exchange is actually a lot bigger than America's Job Bank was with regard to participation when it went away.
Thank you. Mr. Whitaker, did you have experience with America's Job Bank? And what was that experience in relationship to now working with DirectEmployers Association and Vet Central?
We had an experience with the America's Job Bank, and I think when it started, it was new and novel and provided a different layer and a different way of provide service to. But over a period of time, it lost some of that extra service that it could provide. There were issues with the America's Job Bank with funding and being able to continue because of a lack of funding and some commitment from a number of states and other areas to be able to keep up with the new technology and providing service as customers expected that and providing service in a very effective way. So when the America's Job Bank ended, there was certainly, when it was coming to an end, there certainly was a vacuum. And NASWA, as a representative of the state workforce agencies, was aware of that issue. And we received a number of proposals from entities desiring to replace the America's Job Bank We selected Job Central and Vet Central because of their proposal, because it's a free service to the states. It's a free service to veterans, and we believe it's working very effectively to replace the America's Job Bank, and it's getting better every day.
Thank you. Mr. Weidman, Mr. Bozeman.
Thank you, Madam Chair. I'd like to go ahead, with your permission, to pass my time in this round or to skip me and go to Mr. Moran. He's got an appointment that in the future.
Mr. Moran.
Thank you, Mr. Bozeman. Madam Chairman, Mr. Weidman, you mentioned in your testimony, perhaps kind of offhand, about South Dakota has a good program, New York less so. Is there some objective standard? Is there something that I, as a member of Congress, ought to be paying attention to, looking at, that would give me a clue as to how the programs are faring across the country and particularly in my state of Kansas?
The smaller states tend to do much better, Mr. Moran. And from that point on, having said that, it has to do with the culturation and the corporate culture that is built up around the State Workforce Development Agency in that particular state. So that, as an example, New Hampshire had a very strong veteran influence and always has been very good, and has always worked very closely with VA Voc Rehab and State Voc Rehab, particularly on dealing with disabled vets. South Carolina is very good. North Carolina is pretty good. Both the Dakotas are pretty good. Kansas is in the western Kansas, where you're from. It's actually pretty good. It's tougher in the more urbanized eastern part of the state, and that pattern pretty much follows around the country. Is the more urbanized the area, the more difficult it is for a number of reasons. Not that when it comes for veterans employment, I'm talking about. Part of that has to do with the structure of the DVOP LVER program that you can attract people in a less urbanized area for what they're able to pay. And so that has part of it to do with it, and part of it has to do with simply the sociological culture and the respect for veterans that you find often in the more rural areas.
Thank you very much. Let me ask you an additional question, a more specific one. You suggest barring federal contractors who do not comply with Section 4212. Is that, do you worry about with all the consolidation that's gone on in recent years, does that put veterans such a move would put veterans who are working at those companies at a greater risk? Any consequence to the veterans in barring those federal contractors?
You have to have a way for people to reasonably get listed, first and foremost, and you have to have a way to get the listing to people. Vet Central may be one of those means. There are a number of private job boards. The most effective one, which we found, which we endorse in the VFW and others also endorse, is Vet Jobs. So it's, as long as it's clear to the employer community and to the federal contractor community what the requirement is and how to satisfy it, I do not see it as placing veterans at a disadvantage. What often has happened in my experience over the years, and unfortunately, Mr. Moran, I'm an old guy, I've been at this for a long time, since 1973, dealing with veterans employment, when I was doing it as a volunteer while teaching full-time at one of the Vermont state colleges. And once you get veterans through the door, then they prove themselves, and that employer generally says, okay, I want to hire some more of those folks. They show up on time, they work hard, they're drug-free, and they do whatever needs to be done to get the job done and out the door. And if that means staying an extra hour, they'll do it and don't even blink an eye. So the question is getting a leg up to get in the door. So I don't see it as for those who are already working for federal contractors as being an impediment to their future.
Because they've proven themselves.
Because they've proven themselves and, frankly, set a good example, and where they're a smart employer. Ross Perot became a billionaire hiring only veterans. It's useful to remember.
Let me ask Mr. Sharpe, you suggest moving the Office of Contract Compliance to the VA. I want to see if others agree with you. I'm sorry, the Veterans Employment Training, not the VA, the Veterans Employment Training. Why? And do you agree with the Vietnam Veterans Association that disabled vet outreach program specialists and local vet employment representatives should be federalized?
We do believe that it should be moved to the Veterans Employment Training Service. That seems to be the consensus that we receive from those that work in that particular office all across the country. Many of them feel like the program is not working. There's a communication problem, very little oversight, and we believe the only way that we could really improve the program overall is for it to be in the Veterans Employment Training Service program. It just seems logical that, you know, they're already looking at USAR. They already have the job of finding employment for veterans. That should be another component instead of it being spread out in so many different offices. And as far as federalizing, that's the only way that we see that Department of Labor can adequately monitor the money that's being sent to the states. Right now, there's very little compliance. The monitoring is not there. There's no way to actually track where the money is actually going. Every state that we've talked to, I mean, the complaints are just astronomical. And
The complaints by veterans?
Complaints by veterans, complaints by DVOPs, leavers, DVETs. They feel like the program's not being properly administered, and that veterans are not receiving their preferences, their priority in job services. And we just feel like, well, if it's federalized, then Washington can really keep track of where the money's going, how it's being spent, and how it's being used.
Thank you very much. Thank you, Madam. Thank you, Mr. Chairman.
Mr. Teague?
Yes, thank you, Mr. Chairman and Ranking Member. I'd like to thank the panel for being here today and all of the information that you've given, the time that you've given. But I am a little concerned that everybody seems to be in agreement that people are ignoring the rules and just being able to slide by. And you said, Mr. Sharpe, that you think it should be federalized. Has anybody done any scoring or anything to see what the cost of that would be?
Not that I'm aware of.
Do you have any idea how many people it would take us to do it or anything?
May I?
Sure, please do, yes.
The administrative overhead of indirect costs that goes to the states now, out of the $162 million that is currently this fiscal year going out to the states, our scientific wild guesstimate is probably about $50 million worth of services. The administrative overhead, indirect costs, runs as high as 37% of that. For somebody who's making $35,000 a year, in some cases, it's costing the federal government in excess of $70,000 by the time you add direct and indirect additional costs having to do with medical insurance, et cetera, plus what the state is giving out. We hear from DVOPs and LVRs that part of the direct administrative cost, which is travel monies and other kinds of supportive services, is not made available, particularly when it gets to be in a budget crunch in that particular state. Therefore, but the states aren't giving the money back to the feds. So you have to ask the question here, are we getting the bang for the buck, and are we doing the right thing by the young men and women coming home? Not everybody's going to need a vet center, not everybody's going to need medical care, but everybody's going to need a job, whether they're guard, reservist, or returning active duty from the wars. And it is the key readjustment program. And it is the flashpoint of the whole readjustment process, is the ability to obtain and sustain meaningful employment. And so that's why, sir, that we believe that $162 million would be enough to start, but with the cost of federalization, and it would probably be higher pay, and certainly in some localities, that's why we recommended at least $200 million for FY 2010 to handle those transitional costs. Those who wanted to stay as state employees, would then have the opportunity in most states under their own civil service laws to transfer and become regular employment counselors within the office. Those who wanted to continue to work with vets would then go with the feds.
I think probably the answer to both of the questions that you asked about how good a job we're doing for our veterans is probably no, we're not doing a very good job. But I also heard you make a statement earlier in your testimony that you thought the programs work better in rural than urban areas because of they were willing to work for the price that people would pay. Would you explain that a little further?
I'll give you an example, sir. Under Governor Cuomo, I'd returned to New York State and ran the state Veterans Employment and Training Program for 9 years. It was the person that you could attract in Watertown, New York, or in Messina, New York, in the North Country, for what I could pay as a beginning DVOP or LVR, which was about $35,000 a year. That's a pretty good job up there. In New York City, $35,000, you can't live without doing a second job. So I had DVOPs in New York City 15 years ago who were working 3 jobs in order to be able to feed their kids and pay the rent. So that's why I say that if we transitioned over to federal employment, paid people decently, and with the differentials that are paid depending on locality and federal pay, we'd be able to hold our people and not have them working themselves to death by working a second and third job just because they want to work with vets during the day.
Okay, thank you. Thank you, Mr. Chairman.
I'd like to go to Ms. Roof for a second. VEVRA requires federal contractors and subcontractors to compile and submit annual reports on the number of employees who are veterans. Have there been any concerns about the lack of reporting? And what happens when a federal contractor or subcontractor does not submit a report? And who reviews the reports?
You know, I'm really glad you brought that up. That was one of my and AMVETS' main concerns when going through this, as I'm calling compliancy auditing process. There is not enough information out there. And if there is, we were unable to find it. Also, could you ask your first part of the question? I'd like to address each point of it.
There's a requirement in VEVRA to file and submit reports, contractors and subcontractors. Are they doing it? If so, who gets access to the information? Is the information adequate? Because it seems to me the essence of this is trying to get veterans jobs. And if we have this information in the system, we should be able to access it. So is the information in the system, and who's using the information and how?
And again, I think the VA is doing a good job getting the information into the system to a certain extent, but I think that's where it stops. There's no compliancy auditing to check on these companies to make sure that the information they submitted was not just an initial submission to get a contract, that veterans are actually being used. I think that's where the OFCCP comes in. Again, how I touched on doing more audits, because things can look great on the front end, and I'm going to submit all the information, it's going to go into the system, but now who's going to hold me accountable to that, to what I submitted? And as far as who has access, I'm not really sure, to be quite honest with you. I can look into that and get back to you.
I'd ask if any of the other panelists know. I'm certainly going to ask the VA the same question. Any other panelists know what happens with the VEVRA information? Does it come in? Are contractors and subcontractors complying? And are people getting access to the information?
If you mean, does the average DVOP and LVER in a local office have access to this federal contractor list? The answer is, I don't believe so.
Anybody else? Thank you. In fact, I thank all the panelists for your testimony this afternoon. Oh, I'm sorry, you have more? Mr. Boozman, please proceed.
I've just got a couple. And I made reference to it in my opening statement, on the VETS 100 report, how do you think we should disseminate that information? Evidently, it's not getting out. Have you got any sort of advice as to an appropriate way to get the information out? Or?
Well, putting it online is one way, and let veterans market themselves. A lot of this stuff, essentially, the vets who are getting jobs today, more and more are on their own, and that's despite the fact there's some wonderful DevOps and LVERs out there, and people can't get to them, or they don't have time to see the number of people that need help within their community. So veterans are having to market themselves more and more. If, in fact, you had those listings online, the only place where I know there's a complete list that is searchable by state, by zip code, is through the small business that I talked about in Montpelier, Vermont. But there may be other ways. And then you have voluntary efforts, such as put together by DirectEmployers, apparently, is one way to do it. But if you put it online, and we give veterans some additional tools, as an example, there is, for all disabled veterans, a tax credit of $6,000 that the employer gets back for the first $12,000 paid to any disabled vet. Instead of leaving it all up to the employer to do that, give the vet a certificate, simplify that program where he can walk into your office in Arkansas and say, I have a certificate, I'm skilled as an optician assistant. You hire me and you get back the first $6,000 of the first $12,000 paid. You can take off what you owe the feds. So you let veterans go market themselves, and the more you put the things out there, then you will have other services like DirectEmployers, like Vet Jobs, and others who will work with the individual veterans to market themselves. But that begs the question of, does there need to be a publicly funded mechanism to accomplish the most important task in the readjustment process for our younger veterans who are returning home? And we don't have an effective mechanism, and we need to create one. And we stand ready to work with you, Mr. Bozeman, and with Chairman Herseth, and with Mr. Adler, and with all other members of the committee to create a new paradigm that works.
A few years ago, we allowed the ability for part-time DevOps and leavers. Is that a good idea or a bad idea?
With due respect, VVA never supported the part-time DevOps. I mentioned that for 9 years I ran what at that time was the second largest program in the country, and eliminated part-time LVERs, even though that meant at some of the smaller offices, LVR had to split their time between two separate small offices because you didn't get 100% of the person. If you have time, are supposed to be 50% DevOps, you're lucky if you get the equivalent of 1 day a week. And that's just the plain fact, and that's not just from me. You can talk to folks right across the country, and you'll get the same answer. It was not a good idea, sir.
Legion, would you like to comment?
We also agree that it's not a good idea. We hear from DevOps and leavers, again, from all over the country. They've been complaining about this program ever since it was enacted. Many of them complain that they're not working with veterans. They're forced to do other duties, other clerical type activities, and that was not the intention. We were also told that the DVETs are being told not to visit the one-stop offices as they used to, so it's very difficult for them to monitor and ensure that those offices are in compliance. So, and because of that, we've been against it.
Thank you guys for being here. As always, you're very, very helpful. Yield back.
I also thank all of you for taking the time to be with us and for your service to our country. Thank you so very much. You're excused with our gratitude. We have a second panel. We now invite panel number 2 to the witness table. Joining us on our second panel of witnesses are Mr. Lorenzo Harrison, Acting Deputy Assistant Secretary for the Office of Federal Contract Compliance Programs, United States Department of Labor, and Mr. Jan Frye, Deputy Assistant Secretary for Acquisition and Logistics, United States Department of Veterans Affairs. Mr. Harrison, welcome. You're recognized for 5 minutes.
Bozeman, and members of the subcommittee. Thank you for this opportunity to testify on federal contract compliance. The Office of Federal Contract Compliance Programs has an important and unique role in the enforcement arena in protecting veterans' rights, ensuring that covered veterans are provided with equal employment opportunities, and that companies doing business with the federal government take affirmative action to recruit, hire, and promote qualified veterans. OFCCP is one of 3 agencies within the Department of Labor with members with responsibilities for administering the affirmative action provisions of the Vietnam-era Veterans Readjustment Assistance Act. The Employment and Training Administration oversees priority referrals for veterans seeking employment, and the Veterans Employment and Training Service oversees the Veterans 100 and Vets 100A reports. Under VEVRA, federal contractors are required to list most job openings with the appropriate employment service delivery system, and protected veterans are entitled to receive priority and referrals to the job openings that federal contractors are required to list. However, VEVRA does not require federal contractors to give veterans a special preference in hiring. That is, that VEVRA does not require federal contractors to give veterans a special preference in hiring. On average, OFCCP conducts approximately 4,000 compliance evaluations and 900 compliance assistance events annually for federal contractors and subcontractors in supply, service, and construction industries. During the compliance evaluation, OFCCP will verify that federal contractors are listed appropriate job openings with the employment service delivery system so that veterans may be given priority in referral. That is, priority in referral, not preference. So far, in FY 2009, roughly 15% of all on-site reviews conducted by OFCCP have found violations of the mandatory job listing requirement by federal contractors and subcontractors, as we witness the application of private entities like DirectEmployers. OFCCP also receives approximately 500 to 700 complaints each year, of which 15 to 20% of these are filed under VEVRA. During fiscal year 2008, OFCCP received 83 complaints filed by veterans. Over the past 5 fiscal years, 19 complaints resulted in $399,926 in benefits being provided to veterans. Where voluntary compliance cannot be achieved, OFCCP may continue to conciliation efforts with the contractor, refer the matter to the Solicitor of Labor to institute formal administrative enforcement proceedings, or refer the case to the Attorney General for litigation as appropriate. OFCCP does not presently have formal agreements to share such information with other federal agencies. We treat information received from federal contractors during compliance evaluation as confidential. The subcommittee also asked about the most important analysis of the VETS 100 report and associated results. Previously, OFCCP did not analyze VETS 100 and 100A reports, but only verified that these forms were submitted to VETS. Recently, OFCCP met with VETS and secured access to the VETS 100 database. In 2008, we've established a program which is an incentive program called the Good Faith Initiative for Veterans Employment, affectionately known as G5. And it is an incentive program that recognizes the good efforts of contractors in the area of veterans employment. In summary, although we have made progress in addressing equal employment opportunities for veterans among federal contractors and subcontractors, we know that there is still work to be done to increase the employment of covered veterans. OFCCP looks forward to working with our new Deputy Assistant Secretary once that person is announced and on board, and with members of this committee in order to improve opportunities for veterans with federal contractors. This concludes my oral statement, and I'd be more than happy to answer the questions of this committee.
Mr. Harrison, thank you. Let me start with something you said toward the end. You said there is still work to be done. Talk to us for a moment about that. What should be done? What should your department do? What should Congress do? What should federal agencies do collectively, cooperatively to help our veterans get placed?
One is to hopefully have President Obama and Secretary Solis's 2010 budget ratified so that we could go about bringing on 213 new equal opportunity specialists, which would increase considerably, definitively, compliance of contractors under VEVRA. Two, we should be committed to working with the DirectEmployers, a National Association for Workforce Agencies, and other important stakeholders like the ones you've just heard from to ensure that veterans are being helped and they're getting job prioritization and that veterans are getting assisted.
Let me follow up on the second one first. Why hasn't there been that sort of effort with the panelists from the previous panel to reach that sort of positive result in the past?
I believe it has been efforts in the past to work with various stakeholders. OFCCP has been in operation for 30 years. In recent years, there's been an emphasis on systemic discrimination, that is, focusing on classes of individuals who could have been harmed by personnel practices that in some ways de-emphasized focus on VEVRA.
So, I just want to understand. We hired 213 more people that are equal opportunity specialists. And
we haven't hired two.
No, we do that. That's one of the things we do. Tell me what else we should be doing going forward to enhance the cooperation among agencies and with the various entities that were represented by the panelists in the previous panel. I just want to get a better sense of what we should be doing collectively to address the needs of our veterans who want to work.
I mean, very simply stated, Chairman Adler, a commitment to reaching out. Very simply stated, sir. A commitment to reaching out to the panelists, to the diverse stakeholder community for these issues, and a commitment to following up on matters that are distilled in those kinds of discourses, and generally speaking, a commitment to reach out.
I just still understand. The commitment to reaching out, does it come from the Department of Labor? Does it come from some other entity?
It comes from all of us that are involved in seeing to it that veterans are treated as they should be. Those of us interested in ensuring that VEVRA is enforced to the fullest extent. Those of us who are committed to veterans getting the benefits again that they deserve. So most certainly, it includes a commitment from the OFCCP.
It's hard for me to quantify what that means, a commitment to reaching out. I believe in it. I think everyone in the room believes in it.
Well, we have
a sense. Let me just finish my question. Do you have a sense that, in fact, there is a commitment to reaching out on the part of the Department of Labor at this point?
I most certainly do, Chairman Adler. We are, between now and next fall, that'd be fall of 2010, going to conduct some 20-odd public forums that would provide a platform like has not existed in recent years for these issues to be further discussed and commitments and potential commitments made. There'll be over 1,000 compliance assistance events that are non-enforcement driven opportunities, safe havens for partnerships to be made, opportunities to be distilled and defined that would be beneficial to veterans.
I'm truly gratified by the enthusiasm you speak about in terms of trying to reach out to the veterans. Do you have a sense that there are other entities in Washington, within the federal government, that don't share the Department of Labor's commitment to reaching out? And how can we infuse them with your enthusiasm?
Well, I would hope that some of them are sitting as witnesses in the gallery. Otherwise, I don't know of any, sir, that would be certainly against this kind of collaboration. We have strong partnerships with the Veterans Employment Training Service, and we have a strong commitment to collaboration with the Office for Disability Employment Policy at the United States Department of Labor. And as you know, Secretary Solis is very committed to having a vigorous enforcement program that would be beneficial to veterans in this country, many men and women returning from these wars overseas.
I thank you for your testimony and for your commitment. Mr. Boozman.
Thank you, Mr. Chairman. We appreciate you guys being here. Mr. Harrison, you testified that 15% of on-site reviews in 2009 have found violation of the job listing requirements, as well as numerous cases where veterans claim violations of 4212. Assuming that OFCCP found similar and other violations in past years, can you explain the lack of any such data in the annual report required by 38 U.S.C. 4107C?
No, I'm unable to explain that, sir, except that I can say that those data will be publicly available in the report that's going through clearance currently.
Okay. I guess the next question, which we like to know up here, is when could we expect that?
I'd have to get back to you with that for the record for the subcommittee.
Okay. Mike reminds me that it was due in February. So, NASWA has mentioned several concerns about inconsistent application of the laws and regulations by OFCCP field staff. For example, email posting are not considered compliant. Third-party posting are not allowed. Many states lack the technology demanded by field staff. More specifically, NASWA members cited a lack of a comprehensive, official, and accurate federal contractor list, lack of standardized communication protocol during and after audits, and minimal contact between state and regional OFCC staff. Can you comment on that?
What I would say to you, as was indicated by Mr. Whitaker, as is reflected in the correspondence I shared with Mr. Whitaker, we are absolutely committed to having a top-notch professional corps of employment opportunity specialists that abide by our guidelines and regulations, those that were distilled under the Jobs for Veterans Act, which amended VEVRA in 2007. It provides a tremendous amount of flexibility to all of us who would have openings made available in an efficient and effective manner for veterans.
We've been told that DOL canceled the Federal Contractor Job Bank shortly after passage of the Jobs for Veterans Act. Can you tell us why?
No, I'm unable to. I am unable to tell you why, sir. I was not functioning in this capacity at that time.
Okay. And as you've heard earlier, I think there's been concern on our part. I mentioned in my opening statement about really not using the VETS 100 data. I guess the question is, when was the last time that we really analyzed that data? How's it being used?
Well, as I mentioned, there'll be detail in this upcoming annual report, and I am encouraged that we may find via technological advancement ways that were not available prior to now in utilizing information provided by the VETS 100 reports to hopefully improve our evaluations of VEVRA and investigations of VEVRA.
Just one more thing. Is there a central database of federal contractors?
No. Not all encompassing, sir. There are various databases that we utilize to identify contractors.
Is that something that we need to do? Would that be helpful? And I guess the next question would be, if so, who should maintain it?
The department hasn't really arrived at a position on that. I wouldn't want to misspeak about that. It seems like that might be a policy-related matter. I'd have to leave it there, Mr. Bozeman.
Okay, very good. Again, thank you for being here, and we appreciate your testimony.
Yep, thank you. It's an honor and privilege.
Mr. Frye, you are now recognized for 5 minutes.
Thank you, Mr. Chairman, members of the subcommittee. Thank you for the opportunity to appear before you today to discuss VA's acquisition operations with regards to federal contractor compliance. It's a privilege for me to represent the many dedicated and hardworking acquisition and logistics professionals throughout the department that provide mission-critical support every day to ensure quality care and benefit delivery for our nation's most special citizens, our veterans. I've been asked specifically to address the issue of federal contractor compliance with regard to employment of veterans in federal contracting. The committee requested that VA respond to 4 questions, and I'd like to take this opportunity to do so. The first question centers on how VA monitors contractor compliance with 38 U.S.C. 4212. VA contracting officers comply with the Federal Acquisition Regulation. They're required to verify vendor compliance prior to the award or modification of a contract. They may accomplish this by several appropriate means, but in all cases, they rely on the Department of Labor's Veterans Employment and Training Service 100, or VETS 100 database, to ensure that apparent successful officers have completed the required reporting for the appropriate reporting year. To improve VA's oversight and ensure vendors doing business with the VA are complying with the requirements, I have instituted 2 significant changes recently. The first will be the issuance of an information letter to VA's heads of contracting activities, reinforcing that contracting officers must be aware of this important requirement and their responsibilities to query the VETS 100 database. Second, to establish an electronic record of the contracting officer's compliance with the policy, I have directed that VA's contract writing system be modified to add a mandatory feature to require contracting officers to record electronically the execution of a VETS 100 database query prior to award or the exercise of contract options. This feature will create the electronic record that VA will be able to use to monitor compliance on a recurring basis in the future. The second question from the subcommittee inquired as to how many VA contractors are non-compliant. In response to the subcommittee's request, we conducted a review of a statistically significant, randomly selected sample of contract files throughout VA. All contracts in the sample had the appropriate FAR Part 52 contract clauses in place, and all contractors were fully compliant with the Department of Labor's reporting requirements. Third, the subcommittee requested information on any action VA takes to address non-compliant contractors, and last, whether non-compliance affects a company's ability to do business with the VA. At this time, we're not aware of any vendors who are non-compliant. Non-compliance would affect a company's ability to contract with VA. For those contractors deemed to be non-compliant, VA will take action as set forth in FAR Part 22. The first step, of course, would be to notify the Department of Labor and then make efforts to negotiate a mutually acceptable remedy. Failure to reach a remedy could result in termination of the contract for default. Mr. Chairman, I would like to close by thanking you for the opportunity to discuss VETS 100 reporting and the Federal Contractor Compliance Program at VA. We will continue to work diligently to improve and set a standard worthy of emulation throughout the federal acquisition community. I would be pleased to respond to any questions you or the subcommittee's members may have.
Mr. Frye, thank you. You heard the witnesses in the first panel who basically said there wasn't really a problem with vendor compliance prior to the award or modification of a contract, but at least a couple of the witnesses were suggesting there was a problem with compliance after a contract had been awarded or modified. Do you care to comment on that?
Yeah, I would. My view is that the contracting officer's job is to ensure that the required clauses, the required FAR clauses, are in the solicitation, and that those required clauses are then incorporated into the contract award. Secondly, they have to ensure that the contractors have submitted reports to Department of Labor prior to the contract being awarded. And thirdly, they take actions if, for instance, Department of Labor was notified by a veteran that of noncompliance. Department of Labor, I assume, would conduct an investigation and provide us information, and we'd then take action contractually against that contractor. But as far as contracting officers doing anything beyond that, I don't see that as part of the contracting officer's role.
Is there a discrepancy here? I'm we heard the panelists say that somehow it's just not happening. Is it in fact not happening, or is it in fact somewhere along the system there's a breakdown that's preventing the compliance or the termination of contracts or some sort of sanction for those vendors that are not complying?
Well, I'd respond by saying that I have no knowledge of noncompliance. In the last 3.5 years during my tenure with the VA, I don't know of a single instance of reported noncompliance. We did query Department of Labor to find out if we could get specific examples of contractor noncompliance. Prior to my testimony here today, we were unable to get a report that was specifically related to the VA. In other words, they weren't able to sort their database for noncompliance specific to the VA. So I've not heard of any noncompliance in the last 3.5 years that I've been here. And certainly we would aggressively tackle noncompliance if it were related to us.
Let me again understand jurisdictionally who monitors the compliance. Is it Department of Labor that tells you, or do you have your own system of monitoring contract compliance?
We monitor contract compliance by making sure that the clauses are in the required contract. The required clauses are in the contract. We also monitor contract compliance by making sure that the required reports have been issued with Department of Labor, but it's Department of Labor's job to handle any complaints that might come forward. If those complaints were related to a contracting officer from a veteran, we would refer those complaints to Department of Labor, who would conduct the investigation, and we would take action accordingly based upon their recommendations.
Maybe I could jump back to Mr. Harrison for a second. Is it your sense that Department of Labor is hearing complaints and handling them properly, and when appropriate, referring those concerns as well to Department of Veterans Affairs?
I believe so. I'm not quite sure how many, if I'm hearing you clearly, Chairman Adler, have come from Veteran Affairs. You know, we've had 530 veterans complaints filed with us over the past 5 fiscal years, 83 last year.
So I guess I heard from at least one of the panelists in the previous panel that there was a multitude of concerns of veterans not being given the opportunity to have employment, and maybe a real breakdown in the compliance. Is there such a breakdown, or you don't think there is a breakdown in compliance, and maybe there was an exaggeration by a previous panelist?
Well, as I've already stated, 15% of the on-site evaluations, of the 800 some odd on-site evaluations we conducted this past fiscal year, FY08, showed mandatory job listing violations. That would be, I think, 150, if my arithmetic is correct, of the 800 on-sites, or close to that amount. Anyway, my arithmetic, I suppose, is a little off. Showed mandatory job listings violations.
Do we have adequate sanctions in place to punish those employers, those vendors that are not complying?
What we do is make certain that a conciliation agreement is made to ensure that that company, that contractor, reports to the Department of Labor and is underneath a monitoring process that is carried out by the OFCCP until they come into compliance.
Is there any consideration of stronger sanctions than just this probation period? I heard a previous panelist talk about maybe banning such violators from access to future government contracts for some period of time.
Well, OFCCP, the Department of Labor, has not made a position on that.
Mr. Frye, Veterans Affairs, have any concern?
Certainly. I think one of the things that could be done for noncompliance or repeated noncompliance is debar the contractor, eliminate their ability to contract with the government. That is certainly a contractual action that can be taken.
I would think that would be an obvious conclusion. I thank you both for your testimony.
Thank
you. Mr. Boozman.
Thank you, Mr. Chairman. Are the requirements of Section 4212, are they included in the curriculum at the Acquisition Academy in Fredericksburg?
I can't answer that. I can now, but I take that for the record and get you a statement.
Let's go back a little bit. You mentioned that the compliance with clauses required by FAR 52. It appears that there are over 250 different clauses in that regulation. Which clause or clauses are you referring to relative to compliance with Section 4212?
There are two required clauses. First is FAR Clause 52.222-35, and it's entitled Equal Opportunity for Special Disabled Veterans. And the second required clause is FAR Clause 52.222-37, and it's entitled Employment Reports on Special Disabled Veterans. There are some variant clauses, for instance, a clause that you would put in if these aren't commercial items that you're buying. But those two clauses that I just gave you are the two primary clauses that are required.
If there isn't a master list of federal contractors, how can we be confident that all the contractors are submitting the VETS 100 report?
If you could repeat the question again?
If there is no list of federal contractors, master list, how can we be confident that all the contractors are submitting the VETS 100 report?
Again, our requirement, the contracting officer's requirement, is to query the database and DOL, and they can do that in two ways. They can directly query the database, or they can send an email to DOL to find out if that particular contractor has submitted the report.
Okay. Mr. Harrison?
I would have to check back with my colleagues. I just don't know.
Okay, very good. Thank you all again for being here, and we do appreciate your hard work.
I join Mr. Boozman in thanking you. We appreciate your testimony today. We've heard with great insight and interest the topic. Today's hearings provide us with an opportunity to learn more about the ongoing problems facing disabled veterans seeking out equal employment opportunities and federal contractor compliance. This hearing stands adjourned.
Thank you, sir.